everybody. It is such a pleasure to see so many of you here on a beautiful day in Durham, particularly as exams approaching. This is our final fireside chat on responsible data and emerging technologies. For those of you who don't know me, I'm Professor Lee Tiedrick. I teach here in the law school as well as in science and society. And kind of the whole premise of these talks and the premise of the classes I teach and a lot of other professors teach is we have these tremendous opportunities with data and with emerging technologies, and the laws and ethical principles are very uncertain. And the big question is, how can we construct frameworks so society can capitalize on the benefits and mitigate the risks? So we've been looking all semester at this question from various different perspectives, and today we're going to look at the important issue of how this is facing the judicial system. And it's my thrill and pleasure to introduce my colleague, Judge Paul Grimm, who was on the federal bench and was actually a judge for many, many years. So there's nobody better than him to be able to give us some insight on these issues. And he is now here at Duke as the director of the Bolch Center. So what I thought we would do is I'll start asking Judge Grimm some questions, and then we'll open it up because I'm sure all of you have questions and we want to give you an opportunity to ask them too. So just to frame it a little bit, when I think about AI in the judiciary, the judges have a really hard task because there are two aspects of it. One thing I see as a lawyer is that increasingly cases are coming to the courts involving AI. So that is judges helping to make the law of AI. And then there's also the issue that AI is increasingly being used in the court system. So how do we use AI in judicial administration? I would just be interested, Judge Grimm, do you see from your perspective both of those sets of issues really burgeoning?
There's no question that both of these issues are burgeoning. Artificial intelligence, and now of course all the focus has been on generative artificial intelligence as a specific subset of artificial intelligence. Everybody recognizes that it has great potential for doing things that are terrific, and it can also have potential to do some things that are not so terrific. In terms of managing large data sets, having courts figure out their dockets, having courts determine whether or not you can have use these resources to identify the triage of the cases that you want to decide first when most courts are overwhelmed with cases. Those are all positive upsides of how AI can be used in judicial administration. Some downsides of that coin can include what happens when all of a sudden self-represented folks, because that's about a quarter of all the civil cases filed in the United States, maybe a little bit more in some of the state courts, where you've got this gap between those who need lawyers and those who can afford lawyers. What happens when someone goes to a ChatGPT Gen AI software program and says, here are the facts of my case, draft a complaint that will survive a motion to dismiss or a motion for summary judgment in this kind of a case. And boom, out it comes. Or you get the ability to use generative AI and mass file in a lot of the state courts where they have low dollar value like rent court or credit card debt, most of which these cases are filed in huge volume. They are now required to be filed by individuals who have to assemble documents, but if all of that could be put together, you could flood a court and absolutely paralyze it by doing that. The bad side is that you could have generative AI being used to analyze all the decisions ever rendered by a judge, give me the recommended argument that is most likely to persuade this judge. But on the other hand, you could use generative AI to be able to say, these are the arguments that the parties have made. Did they overlook some important precedent that should be considered? So each of these aspects of it has both a positive outcome and a negative outcome. And something that you've dedicated much of your thought to is, so how do you harness thought for getting the best use of this while avoiding some of the bad use? Now, the other thing that you talked about is absolutely a place where the courts are somewhat in a battle of wits unarmed, and that is You are now having cases that are coming into court, whether they realize it or not, where the evidence that's going to have to be decided as to whether or not one side wins or another is going to be the subject of artificial intelligence software applications. And so now what we're dealing with is not how do these systems affect the administrative justice as an organization, but rather becomes the issue of how is this evidence that has to be decided going to influence the fact finder in this case? Does it have the requisite degree of validity and reliability? Validity meaning that the software application produces accurate results, so you have to have some idea about how it was trained and tested, whether there are biases involved with it. There's tremendous issues that come up with in terms of AI-generated evidence that can have biases built into them based upon the data set upon which they were trained. You see this in some of the facial recognition technology, some of the police investigative technology that has produced some terrible false negatives. So judges are going to have the ability of deciding whether or not this evidence meets the judicial thresholds of technical evidence, which deals with authenticity, which means does it do what it purports to do? And the challenge that you have is under the evidence rules, that's a low barrier. It's preponderance, more likely than not. You can get something that's 51% likely to do what you said it did, but it means it's 49% likely not to do it. And so what ends up happening is something that you've been very focused on, Lee, in terms of the broader perspective of this outside of an actual courtroom, which is risk assessment. So what's the threat environment if we get this wrong? If the issue to be decided by the judge in this case is how long someone goes to jail, or something, or whether an important right has been infringed or not, then is mere preponderance, which is just a slight bit more than an evidentiary coin toss, sufficient? Or do we then have to talk about if it's only preponderance and it could have a significant risk, but this is the outcome, the harm that could be done, do we have to have a higher threshold standard? And these are not evidentiary standards that have been well developed for this particular use, because rules of evidence are usually technology agnostic, and the rules of evidence change slowly. So that may have been more of an answer than you wanted.
It's I mean, there's so much there, there's so much to unpack, but let's sort of start with the rules of evidence, because I was never a litigator, but I could imagine a lot of different ways that AI could be introduced as evidence. So one might be, take a commercial dispute, and there's a fight over, or disagreement between the parties over evaluation, over damages calculations. So you may find parties, and maybe it's even happening today, where they're using their AI to compute valuation, to compute what the damages are, and you have, the plaintiff's AI that gives you one figure, and the defendant's AI gives you another figure, and maybe you have AI instead of expert witnesses. And the question is have the rules of evidence addressed what to do in that scenario, or how should lawyers be thinking about that?
So one of the things that you have to sort of keep in mind is that when trial judges have to make decisions, they're bound by rules of evidence. And in the United States, but not so much in any other sophisticated legal environment, our rules of evidence are all drafted with the assumption that the fact finder will be jurors, lay jurors, people who do not understand necessarily very technical science, technology, or specialized information. So we have all kinds of barriers in our evidence system designed to have precautions in place with the notion that a group of ordinary members of the community picked from a cross-section of that community without regard to what their training and experience is, may be having to decide this and being very protective. And what that does is it relies upon the judge as the initial gatekeeper to decide whether under the standards this should be even heard by the jury. When the jury hears it, then they decide how much weight or credibility they want to attach to it. The problem is that the existing evidentiary rules, that initial threshold, the evidentiary concept that's most applicable when you're dealing with artificial intelligence or high technology is going to be authenticity. Does it do what it purports to do? Then you have some of the challenges associated with it is you're a software developer. You have spent time, money, and resources, and you've come up with this AI program, and this, use an example that's actually existing right now. You're a company, you want to hire the most qualified person for this job. You've got thousands of applicants, you don't have the time to look at them, so you hire someone to come in and to identify the top performers in your workforce, identify what their characteristics are, their attributes that you want to have in a new employee, maybe do an interview with them, see how they express themselves, ask them questions, and then based upon that, you come up with an algorithm that's supposed to identify these characteristics. Every applicant then is forced to have a video interview where their facial expressions are looked at, they go over their resumes, they analyze it, and they come up and they say, here's the top employee. Pick this person. You hire them, and the person who doesn't get it says, I'm more qualified, I'm in a protected category, maybe age, maybe race, maybe national origin, maybe gender. They bring a lawsuit, and the issue is whether there was intentional discrimination. Now, right now, how do I test this thing? Well, who are the most successful people in that company? Odds are they come into a group which is not evenly spread throughout society. They may all be male, they may all be of a certain age, and so what has happened is you've tested this algorithm on biased data to produce an outcome. So how does the judge decide that? Well, the judge has to decide it by having enough information about how this software was developed and tested. But you get money licensing that technology, and so you have a confidentiality agreement. So I license your technology, and then when it comes to trial, someone says, well, I need to understand how this operates so I can decide whether or not to challenge it as producing a result that is not valid and not reliable. And then what has happened is, and initially some judges, I think, got it wrong because they were saying you can't have access to it because of confidential commercial information as opposed to trying to come up with protective orders. So the first step is the judge has got to make sure that the parties on each side have enough access to the information, and then in the adversary system, they're responsible for going back, bringing in the experts to try to come in there and challenge it, which then presents a whole other group of evidentiary issues along how do you decide whether or not there's sufficient data to support the opinions or the software application's results, whether or not the methodology is sufficiently reliably applied, and you get into those. So it's a very complex matrix of rules. The existing rules of evidence are not designed for specific technology, but they are intended to be flexibly applied. And so you can take the sort of the standard authentication rules, wash them through the lens that you use for scientific and technical information about error rates, methodology being reliable, peer review analysis, and analyze that, and that process allows you to get a better chance of getting it right.
Yeah, I mean, just a couple comments. We had EEOC Commissioner Sonderling here with us
Right.
a couple months ago, and the case that you described, like these cases are coming up. The EEOC is hearing these types of complaints in the employment context, so what you're describing is not some hypothetical down the road. The other thing that struck me as I heard you explain this is, access to justice is really important. And if we find ourselves in a situation where, judges need to become expert on this, and then it becomes a battle of the experts, the cost of litigating is going to be very high. So you think of the person who didn't get the promotion or the person who didn't get the job. What are your thoughts in terms of just the barrier to entry to be able to bring the cases and the access to justice issues?
Yeah, the access to justice issue is very important because the costs associated with getting into the underlying methodology by which the algorithm. And I've actually had cases as a judge involving the use of AI algorithms in, for example, DNA analysis. DNA analysis is one of the areas of scientific evidence where the scientists have said as long as it's done with rigorous methods of testing, can be reproducible, so it does meet scientific tests of standards. But what happens is a typical DNA standard test may involve 2 or 3 sources. When you have an item that may have been touched by hundreds of people, you suddenly have a much more complicated task, and there are some people who develop some software applications using AI that purport to be able to identify from multiple donors get it down to a single individual set of characteristics where the chances of it being by error or by someone other than the person who has been charged is infinitesimal. The AI algorithms for this are hundreds of thousands of lines long. So in other words, no human can identify and do that computer coding. So you're using machine learning to come up with the code, and is getting to the point now where somebody is so sophisticated that the programmers cannot exactly tell you how it got that outcome. Now, when you have that level of sophistication involved with it, how are you going to attack that? And you talk about access to justice. If you have a prosecutor with the resources that they have, and you have a defense attorney, even if it's a defense attorney represented by a public defender, people who are really bright, really smart, dedicated, but they don't have infinite resources. So that resource imbalance means that there are going to be times when the party that has to challenge evidence being offered against or promote evidence that's being challenged will just not be able to have the resources in order to do it. So what does the judge do in that case? The judge can appoint a court expert, but that's expensive because the parties have to pay for it. Or the judge can use a technical advisor, which is someone who is not going to opine on what the ruling should be, but will help the judge understand the technology. And then the judge ends up having to be the one to ask the questions, not on behalf of one party or another, because that's improper, but to just make sure that the evidence passes that threshold to be able to be admitted. But we're going to have very significant issues of access to justice, which is why, for example, there are some critics about the Daubert test that's used in scientific and technical evidence. And the reason why there's criticism of that is that for those kinds of cases where individuals who may be bringing them, individuals who have important rights or causes of action that they want to bring, are just costed out of it because they can't get the information to be able to challenge it. And that makes it one-sided, and that's a problem.
Yeah. No, they're hard issues. And so we've been talking about sort of sticking on the evidence of when AI is being used to offer kind of an expert opinion.
Right.
But then there's also the issue of deepfakes. And when people saw the picture of the Pope in the puffer coat. But, you know, and I think just a couple days ago, I'm not up on pop news, but there was some headline about The Weeknd, the rock star, and, you know, he was being impersonated by deepfakes. So you think about that in terms of evidence. I mean, oftentimes what somebody wrote, what somebody said, pictures of people can be important evidence in certain cases. And how do judges go about thinking of whether, you know, authenticating that to make sure it's real? And with generative AI, this issue's just going through the roof.
So this is where it gets really, I mean, if it weren't complicated enough, this is where it gets another layer of magnitude. So it's one-ish set of issues that we've sort of been talking about when I know I have evidence that was prepared by generative AI or artificial intelligence programs. I know that, and and therefore in discovery you know that I have it. Now whether you have the money and the resources to challenge it's another matter, but we all know it's coming from this kind of evidence. Deepfakes present a completely different problem. Because now what you have is you have one party saying, this is authentic. They're not coming up and saying, this is the result of a generative AI that took someone's TikTok posting and had enough of their own language in their own voice, in their own syntax, to be able to then take it and have it purport to say something that that person didn't say, or take an image of someone and put it on someone else's body, saying or doing something that is actionable or derogatory or defamatory. And they're not coming out and saying this is the product of AI. They're saying this is genuine. So imagine a recording of someone in a telephone call that purports to be either making an extortion demand or a threat or saying something that they never said. The problem is that when it's audio visual, the impact that that has, if you let that evidence in and you don't know that it's a deepfake, is the ability of jurors to be able to process that. And again, our rules of evidence are focused on the jury being deciding. There are actually some studies that have been done by social scientists that say that even if you tell a jury, this is bogus evidence, this is not authentic, they saw it and they can't, it's like you can't get the toothpaste back in the tube. They've seen it, and even though they know it's bogus, it impacts the way in which they're processing that information. So deepfakes pertain a particularly difficult problem because the party that is putting that evidence out is not acknowledging that it was made by a deepfake AI technology. They're saying it was not. And all they have to do is establish, according to the basic thresholds, that more likely than not, 51%. How can you do that? Well, if you have 5 examples of what I talk like, and they're authentic, and you listen to the deepfake, and you compare it to that and say it sounds pretty much, that's all you need. And so if that's the threshold, and that's the kind of impact that you have, this is particularly problematic, because imagine how it is if someone describes a situation to you that is some kind of a very problematic occurrence. It may be horrific, it could involve injury, it could involve death, it can involve very, very, very troublesome conduct. They describe it to you, see the impact that that has, having heard it described, and then see the visual, if you see it being done, or see it and hear it being done. And this is why, for example, there's such significant changes in public perception of certain aspects involving policing when you can see the badge cams or the dash cams actually portraying what's happened as opposed to hearing the description of it. And when you get this graphic audio or visual, audio-visual evidence, even if you can demonstrate that it's probably a fake, the impact that it can be made when the jury hears it if the judge allows it in. And this is why, again, you have to balance the risk. If the only evidence of this is that one snippet of what one side says is deepfake and the other side says is legitimate, and the impact is so great, that is when judges have to sort of leverage existing rules upon having unfair prejudice to the party against whom it's offered and excluding it. If it's well corroborated by a lot of other evidence, it's not deepfake, then you can say, all right, well, maybe I can have a little bit more of a comfort factor. But this is a huge problem, and it's a huge problem because how do you know, I mean, other than your client saying, I never said that, how would you even go about demonstrating? Because, it's not like Photoshop where you can obviously see the line where someone's head was inserted on a picture. It is, and you may not have the metadata for how it was prepared. So how are you going to go in there and disprove it? And the answers are, we don't know yet. We know the questions to ask, but we have to be cognizant of the fact that we have to ask these questions.
Yeah. And what's interesting is we've been talking about the application of deepfakes in the administration of justice, but then we also see in the popular press that it's also giving rise to a new range of legal cases. For example, with intellectual property law, if you produce a picture that may have somebody's likeness in it, are you violating their rights? If you produce an image that's disparaging of somebody, is there some sort of a defamation claim? So it's coming up in new forms of legal action, and then it's also coming up in terms of the evidence for cases that may not be technical. So kind of coming back to the rules of evidence and drawing some parallels with kind of the world where I've been working, the $64,000 question is, what do we do? Do we need, in kind of the world where I've been active, new laws to deal with artificial intelligence, or can we apply existing laws to new technology? And right now we're seeing both. But with respect to the rules of evidence, do you think they work okay as they are, or do you think it's time to start modifying the rules of evidence to account for some of these technologies?
Yeah, I think that the existing framework for the rules of evidence work pretty well. There is one area of the evidence rules that are going to be debated, and in fact there's a recent article by I think it's the Hastings Law Journal by a lawyer who is specifically focusing on deepfake evidence. And one of the things that makes this challenging, and this is sort of, I apologize to the audience because I look at the entire world through the lens of the rules of evidence. So this is the kind of stuff that calls my kids to give me an eye roll because they say, Dad, no one cares. One of the things that's sort of unique about our legal system with its primacy of juries is that when you have an issue of is this authentic or not, the judge has only a preliminary role to play, and the judge asks herself this thought bubble. Could a reasonable jury find, more likely than not, that this evidence is an actual recording of X? And if the answer is yes, then you put that over here. Then the judge says, could a reasonable jury also find that it's not? And if the answer is a reasonable jury could find either way, the judge doesn't get to make the call as to whether it's authentic or not. It goes to the jury. And the jury is then told something like this. Ladies and gentlemen of the jury, the plaintiff seeks to introduce this recording of the defendant saying X and Y. The defendant argues that they didn't say that. Each has introduced evidence to support their theory. If you find more likely than not that the evidence introduced by the plaintiff more likely than not is the defendant, then you may consider that evidence and give it the weight that you believe it deserves in the trial. On the other hand, if you decide more likely than not that it's not, disregard it and put it out of your mind entirely. Now, I don't know what's in the mind of jurors, but I know that in nearly 26 years as a trial judge, I went back and talked to every juror I ever spoke to. And I had this little image in my mind that when I was saying, now, put it out of your mind entirely. And they're very good because they look at you and they nod. And I had this image of going back there and saying, are you out of your mind? How are we supposed to put it out of our mind? The thing shows the guy saying X, Y, and Z. He must have said X, Y, and Z. And that's the worry that we have. The worry that we have is our system of evidence allows in the area most critical to this, authentication, if it's a fact dispute. There's an old song, a torch song, where the lyric is, you say tomato, I say tomato, you say potato, I say potato, tomato, potato, call the whole thing off. When you have a potato situation about is it authentic, the jury is supposed to decide.
Yeah. Wow.
And so how do they decide when they are, by definition, in areas where the information is above their ability to understand the technology unless it's unpacked for them? And that's where our rules of evidence, I can see in this kind of area people worried about, does that notion, which is very firmly embedded in our rules of evidence, should that be changed? To change that would be a huge change in the allocation of authority between the judge and the jury. And so it would have to overcome an enormous amount of established preference for letting the jury make the factual calls, not the judge. Because again, our evidence rules are based upon an assumption that the fact finder will be juries and not judges. Now in European countries where they don't have civil jury trials by anywhere near as frequently, even in the UK where we got our system, the judges are making that, and then the theory is the judges have a little bit more experience in looking at these and can decide whether or not, okay, I'm gonna let this in, but unless there's a lot of other evidence that I can rely on in support of this, it's not going to be enough to get you across the finish line. And as long as we have these jury-centric rules, in this one particular area, I can see people saying we need to think better about how we're doing that.
Are there, and I will open up for questions in a second, I promise, but are there efforts underway? Are there people who are advocating for these types of rules, rule changes? Do you think we're likely going to see this in the next couple of years?
I think you're going to see people who you are seeing more articles that are talking about whether or not the existing assumptions in the rules of evidence can continue to be sufficient to protect the integrity of the fact-finding process in trials involving highly technical evidence. Now, I will say this, a little bit of a plug here. I co-wrote an article that was published in Northwestern University Law School's Journal of Technology and Intellectual Property. It came out in December of 2021, and a person who you know, Professor Maura Grossman, who's a lawyer and a data scientist, and her husband, Gordon Cormack, who's a computer scientist. It was the first comprehensive published law review article on AI as evidence. That was 2021. There is a new article, the University of California at Hastings, where the author is actually saying we need to modify it so the jury does not have this impact. We're going to see more of this as individual judges are wrestling with these cases. There will be opinions that are coming out. They will make decisions. The risk that you have is if the first opinion on this topic as a first impression gets it wrong, other judges say, well, I'll follow what that judge did, and you can be pretty far down the line in the wrong direction if you're not careful. So the task of having a generalist judge decide these highly technical evidence rules without some guidance, but the reality is, and having served on the Civil Rules Advisory Committee, it can take 4 to 5 years to get a rule change through. And if you're going to talk about underlying premises that are well entrenched in the rules of evidence, then as a result of that, you may find that it takes even longer because you've got to work through those things. So these are the challenges that we face.
Yeah. And it puts a lot of pressure on the judges too, regardless of where that presumption is. And it's great that the Bolch Institute is doing so much work in terms of educating judges on these issues and other important issues. So I promised I would open it up. I could keep asking questions, but who has the first question? Don't be shy. Go ahead, Junpei.
Thank you for an insightful talk. I have a question about education on judges. Given the variety of and complexity of issues that artificial intelligence encompass, I feel that it is essential for judges to have basic but deep and practical understandings on AI. And so the question is, how shall courts educate judges and prepare them for cases that contain issues related to AI?
It's a great question. So the question is how do we enable judges to be able to know what the issues are and what the questions are? When you have something like artificial intelligence, which is so technical, but not just simply, judges deal with highly technical. They have patent cases, they have antitrust cases, they have cases involving engineering, psychology. It's not that technical evidence is itself. It's just that there's something about AI. It is so complicated. The concepts are so hard to sort of explain in some of these software applications how they got the result they did. So how do you do that? There's a couple ways you can do it. First of all is education. And so one of the things that we're trying to do at the Bolch Judicial Institute is identify education programs for judges. Now the good news is when we have had programs for judges in the past on this, there's a lot of interest in it. So the judges want to get that kind of assistance. So that's good news. It's not a lack of will. But then how do you then take that forward? There are ways in which it can happen. As a trial judge, I will give you an example of a technique that I used, and I'm working on a paper about that with one of our professors here at Duke, John DiFigueiredo, is if you have a highly technical area of evidence that the judge has to understand how it operates, and the judge doesn't have that basic area, one of the ways the judge can deal with that is to appoint a technical advisor, all right, a technical advisor. And that you have to have procedural fairness, so the parties have to know about it. They have to be able to say whether they think that person is qualified, make sure they don't have a conflict, they're not biased. And that person then acts to not tell the judge how to rule, because you have to be careful. You don't want to have the judge is required under the Constitution to make the decision. So you can't export that to someone else to make the decision. But you can get that person to have one-on-one conversations with the judge to say, look, this concept, large language model, means this. And when this phrase is used, so that the judge can then decide how to do it. I used Professor DiFigueiredo in an antitrust case. I used him in a multi-district litigation case involving data security breach, involving economic principles that were very sophisticated. And what he taught me how to do was understand it well enough to what I did was I had a tutorial. I brought the experts into court. I told the parties, I want to hear your experts. All due respect, Lawyers are great, love to hear you argue, but you don't know the technology. I want the two experts right here. And I spent a day in each one questioning them, asking them to explain. I would get one person to say, here's how I look at it. I would turn to the other and say, what do you think? And we could go back and forth that way. Now, I will tell you that on my best in those two cases, I knew maybe 0.1% as much of the experts, but I do much more because of that tutorial process and getting them there and having the person, I had to spend the time reading those articles. I had to spend the time understanding the concepts, which I did. And of course, you can't do that with hundreds of cases at the same time, but in the ones that matter, if you do that, the judges can get an education to where they have the ability to have the tools to make the decisions. Hope that answered your question.
I think what's really interesting about that, I mean, just kind of a couple observations, is, certainly what I see in my work is this movement towards multidisciplinary, that it takes a village to figure out these solutions, and we can talk a little bit about this, but I think even sort of figuring out what the laws are going to be, it's going to have to be informed by science. We need standards, we need principles, but even for the judicial cases, it highlights to me that the judges are working with technical experts, and how even that environment is becoming multidisciplinary. And kind of as somebody who spent 30 years in private practice, the word for all the soon-to-be new lawyers out there is, if that's the way your case is going and you're going to need these technical experts, that even if you're practicing law, you need to know enough about the technology to be able to bring in the right technical experts and be able to communicate with them. And kind of on that, I mean, do you find it's easy for lawyers and technical experts to communicate, or do they tend to talk past each other?
There's no question. I will tell you that I'll use an example, and then I'll apply it to what the situation is with this heavy technology. My wife and I have a couple who are dear friends of ours, and their little boy, who I knew when he was about 3 years old, I got to watch him defend his PhD thesis when he was getting his PhD from the University of Maryland School of Medicine in some biological genetic analysis that was unbelievable. And what I understood of his PhD dissertation when he defended it was, "Hi, my name is RJ," and that was it. After that, I have no idea what he said. So you have these situations where the stuff can be so technical that the judge just doesn't have the ability to sort of understand it. When that happens, in the adversary system, in the American system, the judge is not the investigator, like in the European system. The European system, the judge would develop the evidence and say, well, I want this information, I want that information. The way in which the adversary system works in our country is the parties select their own experts, and those experts then, according to standards of law, give their opinions and what they're based upon, and the clash between those two experts is supposed to generate the truth. In theory, sounds great. In practice, maybe not so much. So here's the question. You are a big corporation. You spent millions, maybe billions of dollars developing this technology, and you're in a lawsuit, and someone else is suing you, and they want lots and lots of money. You go out to hire an expert. Are you going to go out and say, I want an expert who will search for the truth? I want them to go through all of this, and I want them to get up there and tell the judge whatever they honestly think using standard systems of science and technology. They don't have any interest in the outcome of the case, whether it helps me or it hurts me. That's what I want. Is that what you're going to hire? Are you out of your mind? You're not going to hire that person. You want the most impressive expert you can afford, who, without sacrificing basic scientific integrity, will analyze and come out with the outcome that supports your case. And the other side's doing the same thing. So by definition, the incentives, there's a motivation on the part of the experts in the case not to give the unvarnished, judge, let me take you a step back and help you understand this, but rather to portray it in a way that is more advantageous. And the lawyers themselves, there are some lawyers who have a technical background. That's why you start to see engineers and scientists who are trained in law have a great advantage because they can understand the technology. But what happens is that oftentimes, as the judge in the middle, knowing what I had to rule on, I often felt that the parties did not give me what I needed to make the decision. In my cases, what I try to do is say, stop. We need to do over. I want you to go out and address the following things and come back, and I want to hear those being focused on. And you can't do it in every case, but in the case that is very significant with a lot, where you're worried about the downside of getting it wrong, you take the time on that, and then you can identify, you can use these tools of having these technical experts. Part of it's going to be education. There's a reference manual on scientific evidence. They're updating that, and they'll have some new technology in that. Problem is, it's about 1,500 pages thick, and it goes through lots of science and technology. So you've got to take the time with busy judges who have overwhelming dockets to be able to sort of teach them. And it takes this community that you're talking about. It takes having scientists who do not have an interest in the outcome of the litigation, being able to help work with judges to help them understand the concept, judges who want to know, and educated lawyers who, even though they have a duty to their client, understand enough to be able to present to the judge the information broken down in a way that the judge can understand it and process it. And that is far from perfect. It's the best our system can accommodate.
That's hard. Who has the next question? Go ahead.
So I have two questions.
All right.
One was like a business question. Like, given your time like as a judge over the last 26 years, do you see now like what opportunities do you see like for using AI to like assist lawyers and judges? And then the second question I had was like, given that AI can like, or you can submit it like the details of the case and be like, like what are some questions to ask this witness, or prepare me like an opening statement. Like, how do you foresee that influencing the role of like a lawyer?
Yeah, that's a great question. I guess what I would say is there's this tendency to sort of, and we all do it, portray this new technology as either good or bad, right? But technology is agnostic. Think of a hammer, all right? A hammer's a tool. Can you use a hammer to, if you're gonna make something with nails and wood, a hammer's a pretty good tool. But you can also use it to hurt someone, right? So it's, the tool's agnostic, it's how you use it. Does AI have potential uses? Absolutely. So for example, if you had artificial intelligence, it was, and again, it's who designed it, who crafted the algorithm, and what was it trained on. But let's say it was trained on, you had 20,000 cases on a certain legal area that were all of the cases from the Supreme Courts, the Courts of Appeal, and the trial courts of the United States. It had put all that in there, and you have facts of a particular case. You're a lawyer. You go into this and you say, here are the facts of my case. What are the most important precedents that I should focus on that the court, either the trial judge or the appellate judge, is going to look at in order to resolve this case so that I don't miss them, and then I can do the work to analyze them and apply them to my facts. That's a good use, right? Because reading 26,000 cases, if you charged your client for doing that, there would be a tremendous cost associated with that. There's not enough time to be able to do it the way artificial intelligence could do. Similarly, if you had a brief from someone else that you got, and you wrote a motion and they wrote an opposition and they're saying you're wrong and these are the cases, and you wanted to see whether they had missed some cases that went your side, you could plug it in there, find out what it was, then you look at the cases independently and make the argument. That's a good use. But a bad use would be if you said, all right, here are the facts of the case. You've been trained on the law. Write the memo for me. And then you submit that memo. Because there's some ethical obligations when you do that. The lawyer is making some representations by filing that. And the other thing you have to be careful about is that whatever sources are reported to you from the AI application, you got to make sure that that's not a hallucination. Because oftentimes some of this generative AI will come out very persuasively and cite something that doesn't exist. So there's a downside on that as well. What judges get a little bit worried about is you can literally take every decision that was ever issued by this judge in the field of law, and you can go in there and say, these are the facts of my case, this is the kind of area it is, go in there and analyze all the cases that Judge fill in the blank ruled on, and craft for me the most persuasive argument to use for that judge, or you could even try it with a jury. And then what you get is if the artificial intelligence is a tool that is then used like any other tool by the lawyer to do their job appropriately, independently, it can be good. Just like when I went to law school, when we rode horses to the law school and had quill pens, wore white wigs, right? You actually had to use law books and open them up, and you would go, you had this case, and then you would get this reporter that looked at it, and then you'd have a flimsier copy, and you would look at all these things, and we had to battle dust mites. It was a dangerous profession. Then all of a sudden, Westlaw came out with you go on there and you do a natural language search, and boom, you've got a whole bunch of stuff. And we looked at it and said, back in the old days, you had to be tough to do legal research. Now you just put it in the computer. Well, that's not true, of course. It's just as tough to do it. But that's an example of technology helping you, but it doesn't replace the obligation of the lawyer independently to exercise that judgment and knowledge and verify that it's accurate and not as a substitute. Now, there are some people to the access of justice that would say, well, that's great, but when 80% of the people who file cases in the United States can't get a lawyer, why shouldn't they have access to some of these, law bots or whatever you want to call them, who can help them with this information? It's a tougher question, because now you get into an access to justice, you get into you don't have the same kind of implications, because the individual person cannot lie to a court and must be honest, but they are not governed by the ethical obligations of an attorney. So it has the possibility of really helping, but also has to be done in a way that doesn't undermine the benefits of what you could get if you used it right. Did that answer your question?
Okay, I think there's another question over here.
Sure. Yeah, thank you so much. As I listen to this conversation, I'm struck by this notion that AI can increasingly be a black box, right?
Yep.
There comes a point at which it's unintelligible to human intelligence what the decision-making factors are. When I think about the legal system, one of the foundational tenets of it, as I understand it, as a non-law student here, full disclosure, is due process, right? Is the idea that central to the integrity of a system of justice is the idea that you can identify a clear process, identify clear thinking patterns, and use this kind of adversarial process to find where things break down. And those things don't necessarily feel compatible to me if you have a black box that you can't understand by humans going into a process that is supposed to be all about process. How do you square that circle?
Yeah, I think that is that's the transcendental question now that is challenging the people who are thinking about how this technology could impact on this system, okay? And black box means simply that you've got this computer, you've got this algorithm, you've got this software, you put data in there in some form, it analyzes it and gives you a result. And the result, you cannot explain how it got there. And so one of the things that you hear about in a lot of the different areas, I've done work with the American Association for the Advancement of Science and the National Institutes of Science and Technology, which is part of the Department of Commerce. They're all looking at some of these things, and Professor Tiedrich has done a lot of work on this and is one of the forward-leaning thinkers in the entire world about this stuff, and has been talking to policymakers about how do you have to deal with this. And part of it is that one of the things they talk about, ethical AI, all right? They talk about explainable AI, all right? Now, it's one thing to have explainable AI is if the programmers who put it into the system that produces the results can explain how it looked at it, how it was trained, and how they got the outcome. But when those people who are involved in making it say, we can explain it up to this point, but at this point the machine learning took over and trained itself to make these decisions, and we're not sure how they did that, that's when you get that black box outcome. Now, does it mean that you can never rely upon black box analysis? Well, you could come up with a way where you had known outcomes. Let's say, for example, that you knew by ordinary scientific or technical methodology what the right result was under this data set, okay? You had the answer. You then apply that to the black box and see did it get it. If you find that 99.9% of the time it got right on, and 0.0001% it didn't, then you say under those traditional evidentiary standards, is that good enough for the jury to be able to understand? And as long as we explain that there's a downside, the jury can decide how much to weigh it. There are people who will say you don't need to have a clear box to where you see all the gears moving. You just have to be able to validate independently what the results are. The problem is, how do you do that when the person who did it can't really describe it, and where you may not have a sufficient database, right, upon which you can test it to say, I've got enough yeses when I've used these under the circumstances in which it's going to be offered in this case, to be able to say, I don't know how it got there, but I rely on it. It's kind of like I say what I am with like Waze, right? I'm driving along in Waze, and Waze says turn left. I don't think about it. I don't know how Waze did it. I'm just turning left. As a matter of fact, if Waze told me to drive off a cliff, I'd probably drive off the cliff, because that's the fastest way to get to the bottom, right? But the point of it is that it assumes that if it is a black box, that you have the ability to test the outcome under a data set where you know what the right outcome should be, under enough circumstances that you're predictably going to find in this area of use to be able to rely on it. And that kind of testing, do you think that the person who's spending money to come up with the black box technology is going to do that? No. They're going to start licensing it, and then that's what the issue is. And this is exactly what Professor Tejic has been talking about. To wait for the rules of evidence to go, to wait for legislatures to legislate, or agencies to regulate, takes a lot of time. So what we need to do is we need to bring in the stakeholders, and she's much better qualified to talk about that than I, to come up with guidelines, to come up with standards, to come up with performance criteria that can allow in various types of technology that have guidelines and best practices built in, but also can associate that key question that the evidence rules allow for, even in a blunt way, which is, if we get this wrong, what's the consequence? And will we tolerate that amount of risk to allow this to come in? Where the outcome can produce an unacceptably wrong outcome or unfair outcome, then you should not let it come in. That's the way the final balance should be. And I think that's kind of the arc at which this is going to go. But the problem with coming up with rules of evidence design with specific technology is, what do you do when the technology changes so fast that next year they're no good? You're back to where you started from.
And I think it just really underscores why it takes a village to solve these issues, and the lawyers need to be talking with the ethicists and the technical experts to figure out what those benchmarks are and then how to apply them in individual cases. So I think there was a question over here.
Yes, sir.
Yeah, I'm really interested in like the training process that by which like we train these AI or machine learning models, and how much that can influence their performance results.
It's
So,
huge.
as a judge, like how do you, without going through each training datum individually, when it's mass amounts of data that are being fed into this, how do you assess bias and recognize, oh, this may be hand-picked data that it was fed to produce certain results?
Yeah, I mean, the problem of bias in these sophisticated algorithmic software applications is huge. And you know, just like, I mean, 20 years ago, the notion of implicit bias in systems and processes was poo-pooed. Now it's recognized that of course there's implicit bias, and is now starting to be recognized, whereas 20 years ago it wasn't. But you can have bias come in lots of ways. It can be unintentional bias. It's just in terms of where are you training the data. Typically what happens is they're going onto the internet, all right? And this sort of takes into another area that we haven't really touched on, which is privacy, because a lot of people go on to sources which collect a lot of biometric information about them, or information about what their thoughts and what their desires are and everything, and then they use that data to train it. But let's just take something simple like facial recognition technology. So you go out there and you train your facial recognition technology, and the theory is that you've got an algorithm, all right, and you have an algorithm, and you want to teach the algorithm to distinguish between dogs and cats. And so you show 15,000 different pictures of dogs and 15,000 different pictures of cats, and when the algorithm goes back and says, this is a cat. If it's a dog, then you penalize it in some technical way, or you train it that it's not, and then ultimately, you don't have to individually decide what it is. The machine now has determined how to look at an image of an animal and say it's a dog or a cat, by whatever level of certainty that it does that. So you've got to have access to a broad population that will give all the potential variables in terms of what a dog and a cat look like. With facial recognition technology, remember that anybody can do this. You can get an AI, you can go to GitHub and some of these other sources, and you can get sort of out-of-the-box AI technology, and then you can configure it yourself in order to do things. I can't, but there are people who can, all right? And so you come up with it, and you spend money on it, and now you want to make money on it. So you go out and say, I've got the technology that will allow you to recognize faces. You've tested it, and you say, well, I've tested and I'm satisfied. But that's something that you developed, and there's certain protection for your intellectual property that you get. But what they've had in facial recognition technology is it's predominantly tested on white, male subjects. And so when it was being used to a population, that the data was not sufficient for it to make the discriminatory factors about what this person is, they have actually had cases where for example, there will be like surveillance technology. Let's say someone breaks into a store and steals something. They've got a video. They've got one snapshot of this person's face. They take that snapshot. They run it through the Department of Motor Vehicles, motor vehicle licenses that have the picture, and they come up and they say, this is the match. They go out there and they arrest that person, and it turns out that after they've been held for 48 hours or longer, that they're absolutely not the person who did it. That's an example of testing it on a data set that was not inclusive enough for it to be able to make the kind of discrete discriminations between what is a qualifying match and what is not a qualifying match. This happens all the time. You can have implicit bias in the use for the employment where you're a company and all of your high-level performers are male. And so all of the characteristics that this artificial intelligence has been trained to say is a characteristic we want to hire and replicate for a successful hiree has been based upon a biased set of data that was staggered in front of a discriminatory workforce that consisted predominantly of males. And the law says that might produce a result that produced an actual discriminatory result where the person picked was not picked because they were the most qualified, but they were the most likely to emulate a person in an unprotected category to the disadvantage of someone seeking the job in a protected category. So how do you figure that out? Well, the burden is on the party offering the evidence to demonstrate that it results from a system or process that is shown to produce accurate results. But here's the rub. The level by which you have to do that right now is 51%. That is not a very good go, no-go discrimination, where discrimination in terms of what should or should not be allowed is a pretty low barrier. That's why the notion of prejudice has to come in, is when the outcome, and this is, for an example, I'll give you just another example. And there's a concept in artificial intelligence training called mission creep, where you design something for this purpose, and it may be very well designed for that purpose, but you start to now change the circumstance under which you're using it. There's a well-known software program used by a lot of state probation officers and pretrial supervision officers called Compass, and it's supposed to look at a questionnaire filled out by a person in the criminal justice system, identify the risk that they will commit another offense before their trial or after they have completed their sentence, and come up with a risk predictor. It was designed, bless you, it was designed to help identify people who needed anger management or drug testing or mental health treatment to help them succeed while not being locked up. It data creeped to the point where it was being used to predict how long a sentence should we impose. Because the more likely of a risk, the more we should lock you up to keep you from being out in the street to commit a new crime. So the purpose, which was a good purpose it was developed for, gradually, it was not trained for that, became used to impose a length of sentence. And ProPublica did a big investigation where they actually went back and they looked at the results of this and saw that it had a tendency to underreport the people who were actually more likely to commit if they were white, and over-report the people who are likely to recidivate if they were non-white. And they just found that that was based upon the data testing. Well, you would never know that unless you could go in there and see what the results were and then test it against individuals for whom those results have been shown and determine it. So it's a tremendous amount of work to be able to do it. But this notion of bias in this type of evidence is hugely important and needs to be understood and needs to be addressed. So it's a very important issue, but we're sort of still at the beginning phases of figuring out how to sort it out. Did you have a question?
Well, I think the ProPublica Compass example is a great example of why if you're waiting for an outcome or if you're using the outcome to determine whether or not something comes in, I mean, we're years down the line and all those people are in jail longer than they should have been.
Oh, yeah.
So, I mean, the damage has already happened and, I mean, sorry, this just keeps me up.
Well, no, it's very troubling, right? And that's where the notion of risk comes in, okay? Because if the risk is, let me give you two examples. The one that you're talking about is we're going to decide how long do we lock this person up, right? Knowing that is a deprivation of a liberty interest is one of the most important things that we can protect in our legal system, or should protect, right? Now let's take a look in a different context. It's civil discovery. It's commercial litigation. And the issue is whether or not in a terabyte or an ectobyte of information have we identified all of the documents that might have something to do with this issue. All right, and let's go in there and we take this technology-assisted review platform, we train it to think what's relevant and not relevant. We go out there, we took it against a million different documents, and it comes up and it has like a 90% recall and precision accuracy. Human beings, when they're tested that way, it's like 60%, right? So that's pretty good. So we have a 10% error rate, so it could be wrong 1 out of 10 times, right 9 out of 10 times, okay? But the risk is, if I don't have it 99%, then do you really need those extra 1,000 documents that you would get across all you got? No, the world's not going to end. So you can accept that amount of error. If you're deciding how long to put a person in jail, and the options are probation with mental health counseling and drug treatment, or life imprisonment with no possibility of parole, and you guess wrong on that, and you don't have the ability to go in and a priori and look at all the factual data, but it's only done 10 years later, then someone's lost 10 years of their life. That's the unacceptable risk, which should make more than just 51% required before it's used. And you should be very careful when you have the ability to understand how it was designed, that it's not being used for a purpose it wasn't designed to do, and tested to be able to show you have you have a sufficient accuracy level to deal with the risk of getting it wrong. And that second part, the risk of getting it wrong, is the one that should be the swing vote for whether it's allowed or not. And we really are just at the very beginning of judges trying to figure that out.
So we're at time, but I know there's a couple other questions. If we're not kicked out of the room yet, do you have time for a couple more?
Yeah.
I know you had your hand up.
I can talk all day about this. This is what I live on. I have no life.
Go ahead.
I don't want to keep everybody, if you're around to just talk.
Yeah, I have a little bit of time, I think.
Great. Well, please, this was really informative, and we really could have kept going on, but I know everybody has to get to class. And thank all of you, and please join me in thanking Judge Grimm for